Welcome, and thank you for attending our first quarterly docket of the year. This is a quarterly review of all things compliance as they relate to absence and disability. A couple of things to note before we get started. We are recording this session, and all registrants will receive a copy of that recording as well as a copy of the presentation deck. If you have any questions, please use the question feature at the bottom of your screen, and we will answer as many of those questions as we can towards the end of the presentation. Our presenters today are all from our Reliance Matrix compliance team. They are Lana Ruprecht, Director of Product Compliance, Marty Carty, Senior Compliance Consultant, Armando Rodriguez, Product Compliance Counsel, Shelby Felton, Director and Product Compliance Counsel, and Eric Broutman, Director of Employment Law and Litigation Counsel. Now I'll turn it over to Lana to get us kicked off and to go through the agenda.
Thank you, Monty. I am excited for today's presentation. We have a great agenda and wonderful speakers lined up today. We will start with Shelby Felton, our PFML expert. She will walk us through important updates to state paid family and medical leave laws and regulations. This is a fast-moving area, and we are thankful for Shelby to help us through this. Then we have Armando Rodriguez, our compliance counsel, who will provide an update on recent legislative developments. Eric Broutman will be next, our litigation attorney. He will share some recent regulatory guidance and enforcement and litigation updates that are notable. And then finally, we have Marty Carty, who will lead us for this quarter's compliance lesson on ADA association discrimination. Then, time permitting, we will take questions at the end. And with that, I will turn it over to Shelby.
Thank you so much, Lana. So I'm here to talk about all things PFML, paid family and medical leave as usual. I always like to point out first our statutory page, which provides all of the PFML information you could ever want for each state and for each category you might need. We're going to jump into the starting block for our upcoming mandatory PFML states. So this is our starting line for today. And notice I'm emphasizing today. This could change tomorrow. I do want to point out that Colorado went live on January 1st. The state plan, all claims are done through the website. There's no claims forms. The state has done a really good comprehensive application guide for employees in the state plan. Unfortunately, there's no employer communications through their portal yet. Private plan claims forms are being approved at the carrier level, and I'm happy to say that, of course, ours are approved. Private plans are still working on what quarterly reporting requirements are going to look like. And I'm going to emphasize again, for Maryland and Delaware, these dates are for at this moment in time, as we will talk about. Let's get started with the legislative landscape in our mandatory PFML states. So California's SB 951 is old news. We've blogged about it twice. But the wage cap, became effective on January 1st of 2024. I want to remind everyone that during our last quarter update, we provided state-issued guidelines that state voluntary plans can retain the wage ceiling. That's an important change that happened last quarter. In Connecticut, they have told us that the Paid Leave Authority Board is going to propose some technical changes this session. Reporting deadlines, some penalties, interaction between state and federal programs. They're going to look at some changes to the definition of municipality and how tribes participate. But the big news is that the authority is not going to push legislation similar to last year relating to the offset of short-term disability benefits against paid family and medical leave. I feel like there should be trumpets. Delaware, possible delay of the program by 1 year. That's huge. We're waiting to see if that legislation is going to be proposed. We've also heard that they may be proposing bills for the 12-month benefit year. They have this strange thing where it's sometimes 12, it's sometimes 24. We're hoping they're going to clean it up for just 12 months. They're going to look at, hopefully, whether bereavement leave was intended to be provided in the plan. And also about, they have this reclassification of employees. So an employee could be covered. They're going to be looking at that this session and hopefully look at eliminating the 2 tiers of benefits based on employer size. I get asked a lot if we participate in the legislative process, and the answer is yes. Industry and advocacy groups participate all the time and are proposing changes in these plans. Maryland, another trumpet blast. This program was already delayed by 1 year. 2 days ago, the division announced that they are going to offer legislation to push contributions back 9 months from October 1st of this year to July 1st of 2025. And they want to push benefits back another 6 months from January 1st of 26 to July 1st of 26. There's also some additional proposals, amending some definitions like wages. Nothing as big as moving the program again. Massachusetts, we've blogged about how their top up of PFML benefits started on November 1st. Originally, the state said that employers had to allow the top up of benefits regardless of internal policies. Now there's been guidance, and I've provided a link there in the slide. Employers may allow top up subject to employer leave policies. Additionally, there are 9 combinations of bills that have already been proposed, including coordinations with other benefit types, notices, reporting, whether additional business entities are going to be covered, and most important, whether bone marrow, organ donation, bereavement, and pregnancy loss are going to be added as leave types. Moving on to our additional mandatory states. New Jersey has reintroduced some bills related to, and this is a laundry list, so we're really going to be keeping an eye on this. There's coordination of benefits. There's computation of benefits, eliminating language that family leave insurance doesn't provide job protection, changing covered individual definitions, adding qualifying military exigency, eliminating the waiting period for TDI, changing some financial eligibility rules, job restoration, and adding intermittent leave to TDI. Bill 5166 also looks at giving employees more rights to reinstatement. New York, we haven't seen changes here for how many years? The governor is proposing changes. I've added 2 links for you. Increasing the DBL benefits, as well as adding 40 hours of paid leave for prenatal care. These are huge issues. I encourage you to take a look at those articles I've pinned. There are 15 combinations of bills proposed right now in New York, increasing the TDI rates, temporary disability rates, and the maximums, changing contribution rates, changing retaliation and interference, expanding eligibility for reinstatement, adding leave for stillbirth and miscarriage, as well as bereavement, military exigency. There's changes to reporting, increasing leave times. This is a new one, adding menstrual complications and menopause as a leave type. Oregon, we've been praying to get more clarification on the coordination between paid family medical leave and Oregon family medical leave. the mini FMLA. So right now, they are telling us that they are going to present two bills during this short session. The first one's going to have some technical fixes, and it's going to have the coordination issue. They're talking about eliminating some of the leave types that OFLA provides that overlap with Paid Leave Oregon. The second bill that they're going to propose this session is some sustainability issues, looking at contribution rates, benefit rates. We blogged about Senate Bill 913. I want to remind everyone that became effective January 1st, which means contributions are now capped at the Social Security wage limit. Rhode Island. Rhode Island's looking at adding siblings, grandchildren, and care recipients eligible for care insurance benefits. Rhode Island's also looking at increasing the maximum temporary caregiver benefit from 6 weeks to 12 weeks, as well as increasing the dependent allowances. Washington, there are 7 combination of bills right this minute, including the disclosure of health information. They're looking at whether or not employers that have less than 50 employees are going to have to start contributing to the plan. They're also looking at some appropriation issues, as well as some continuing health benefits for firefighters on PFML. Now let's look at the regulatory landscape in our mandatory states. There are always rate changes that go into effect in most states January 1st. You can find all of those rate changes on the statutory plan website, as well as a blog that we did on December 1st of 2023. California has some regulations pending about the submission of private plan approvals and renewals. They may start wanting those 30 days before the effective date. They're also looking at addressing some definitions and some eligibility requirements, as well as looking at qualifying exigency leave. Colorado, we've blogged about extensively. So their rule changes went into effect on January 1st. Remember, they moved from a measure backward benefit year to a measure forward. They changed the definitions of application and benefit year. They changed to quarterly reporting for private plans. They changed the definition of what a regular work schedule is so that it's aggregated amongst all work hours for all employment. If benefits change if there's a schedule change or a change in the state average weekly wage. There's also changes that went into effect for the coordination of benefits when going from state to private plans. And they moved the amendment rules all to one rule, Rule 9. Connecticut had changes that became effective January 1st. The vote in Connecticut can now occur no more than 6 months prior to the effective date of the private plan. Applications must be submitted and approved a month prior to the effective date. Otherwise, you have to wait till the next quarter. There's also now a 90-day notice requirement to return to the public plan. DC has proposed updates to its PFL program to provide for personal medical leave for prenatal leave, expanding the length for leave events, and clarifying the sequence of how does it work when you go medical leave, sick leave. They're also looking at PFML being exercised during a 12-month period following the start of the qualifying leave event. Delaware has already proposed several changes, and we're in the 30-day comment period. That started January 1st. The state is proposing doing something similar to FMLA, where if you take a break in employment of up to 7 years, you may still meet the 12-month eligibility period. They're making some changes to help with coordination of benefits when there's workers' compensation or unemployment. short-term disability, and PTO. Our next look at regulations, we're probably going to see some coming from Maine. We know we're going to see some coming from Maryland, New Jersey, just some little ones to make the regs consistent with the statute. We've blogged about Oregon at length. Batch 8, we blogged about. Batch 9 rules made batch 8 permanent. So that were affinity rules, benefits rules. And guess what? The hearings have been scheduled for batch 10 rules. Hearings will be in March and the rules will be finalized in April. We anticipate that those regulations will be related to the coordination of benefits between OFLA and Oregon PFML. There's also some proposed rules about how PFML works with bankruptcy and child support payments. Washington had regulations that went into effect at the first of the year about employee information being available to employers and the rate setting at 1.2%. What new mandatory states might we see this year? There's 8 of them right now. I've identified their potential effective dates and whether or not they're state administered. Arizona's bill is noteworthy because it's got 26 weeks for your serious health condition, as well as 24 weeks for everything else. Hawaii's notable. It's got 16 weeks of leave. Michigan, we thought was going to pass. It's at the top of the governor's list. But what we're hearing from the Democrats who are in power is that the bill as proposed is too rich. Businesses are really opposed to it. It's 15 weeks in a 12-month period, and it also expands on the leave reasons. Missouri's got 2 bills pending for state-administered plans. I really think we might see New Mexico this year. The House Speaker says they're determined to get it passed. So we're looking at the usual leave reasons, the usual 12 weeks and 12 months, employer contributions, and employment protection after 90 days. I've included North Carolina here, but it sounds like there's little chance of it passing, and that's the same with Pennsylvania. Virginia, this is strange. Virginia's already a state that allows NCOIL, or you can provide PFL as an insured product, but they have proposed a mandatory paid leave for 12 weeks and 12 months for the usual leave reasons. West Virginia is also out there, same 12 weeks and 12 months with the typical leave types. I'll mention briefly Nebraska. They just proposed a state-administered plan. And interestingly, last year they had a PFML bill that had private plans in it that carried over to this session, but we've had no word on that since June of 2023. So I just mentioned providing PFL as an insured product. You may hear this called NCOIL, which stands for the National Council of Insurance Legislators. They adopted a model plan for states to provide, for their insurance divisions to provide PFL as an insured product. It's usually an amendment to the state's insurance code. Typically, these benefits can be written as an amendment or a rider to a group disability income policy, or included in a group disability income policy, or written as separate. You can have all the similar ideas that are in any PFL. You can offer paid leave benefits due to birth, placement, bonding, care of a family member, military exigencies. These plans typically offer no direction in terms of duration of benefits or percentages of wage loss. So that's up to the employer what they want to provide. Currently, we have 6 states that allow this. Now we have 2 where it's been proposed already this year, and 2 where we've heard it's coming. This is our map, our big picture map of PFML laws: mandatory, voluntary, pending legislation, failed legislation, and the NCOIL and private insurance models. This map changes frequently, but it's up to date as of today. And now I'm going to turn it over to Armando for our legislative update.
Thanks, Shelby. So, first off, we're going to talk about the Pregnant Workers Fairness Act. This was passed last year, became effective on June 27th, and right now we're waiting for the final regulations. We're expecting it any day. As of the time of this presentation, final regulations are still pending. But keep an eye out. As soon as we get those, we'll be blogging about it. We'll be talking about it, and we actually have a white paper talking about pregnancy protections that will be coming shortly after the final regulations being published. So, just to talk briefly about those proposed regulations, we have a few key takeaways I want to point out. We've talked about this before. I think we talked about it during the last docket. We blogged about this, but at the same time, just a few things to keep in mind. Broad interpretation in favor of the employee. We're looking for employers to act quickly to consider and grant accommodations, quickly, because it is a short-term, or I should say, a relatively quick turnaround time. And the last one I want to point out is that medical documentation is prohibited for certain accommodations. Now, we were all really excited because earlier this month, the EEOC and DOL released a joint statement about the Pregnant Workers Fairness Act and the Pump Act. And we were hoping that this was going to include something about the final regulations, but it didn't. It was just talking about the protections are being offered, but they did provide a bunch of links to resources. So there was resources on maternal health, a know your rights resource, resources related to the PWFA, and then the DOL also released a industry specific webinar series for the Pump Act, and we have all those linked right there. Now on the state updates, the state legislative updates, we're going to start off with Illinois. These are all laws that took effect January 1st. Illinois started by making a amendment to their Victims Economic Security and Safety Act, or VESA. And in addition to the current protections offered under VESA, all employees in Illinois are provided with 2 weeks of leave for the death of a family or household member who was killed in a crime of violence. And like I said before, these are 2 weeks in addition to what's already available under the law. The blood donation leave was amended, and now organ donation is available. And that applies to employers with 51 or more employees who have been employed for full time for at least 6 months. And in addition to the 1 hour every 56 days for blood donation, eligible employees can now take up to 10 days for every 12-month period to donate an organ. Lastly, in Illinois, we have the Child Extended Bereavement Leave, or Zachary's Parent Protection Act, which provides eligible employees of covered employers with unpaid leave in the event of a loss for suicide or homicide. And this covers all employees in Illinois, but the entitlements are staggered based on the size of the employer. And like I said before, we've blogged about this. There's a link to the blog post about the Illinois leave law activity right there. Next, we move on to California. California, effective January 1st, now has a reproductive loss reproductive loss leave, and that provides with 5 days of leave for miscarriage, failed surrogacy, stillbirth, or an unsuccessful assisted reproduction act, such as artificial insemination or embryo transfers. It also includes failed adoptions. And then last on our legislative updates is an update to the Nevada domestic violence leave, which is also effective January 1st. And now, in addition to domestic violence victims, it also covers victims of sexual assault. So now I'm going to pass it over to Eric, who's going to give us the regulatory guidance.
Thanks, Armando. I appreciate it. I'm going to go through things fairly quickly because we have a good amount of things to go through. So starting with EEOC's proposed enforcement guidance on workplace harassment, the EEOC makes clear that workplace harassment can happen for any protected category, not just the typical ones that we usually think of, which are harassment based on race or harassment based on gender. The EEOC lets us know that that can include ADA type harassment for disability discrimination, or under GINA, which is the genetic information law. As well, the EEOC really emphasizes the fact that and adds pregnancy, childbirth, or related medical conditions such as lactation or sex-based protected characteristics, in addition to reproductive decisions, including contraception, abortion, or as well as protected from harassment. So the key there really is if there is a protected category at play, any level of harassment based on that protected category is going to get employers into trouble. And we have a link to view those proposed guidelines as well. This is not as directly applicable to private employers, but still contains useful information, is the EEOC's workplace accessibility guidelines. These are really tailored toward federal employers and federal buildings, but if you have a business, if you're an employer that is forward facing to the public and has public customers, then it might apply to you as well. And the fact that you need to provide access to buildings, facilities, and physical spaces to those with disabilities, as well as access to information that's for hearing impaired or visually impaired customers and individuals of the public. Moving on now to the exciting stuff, the enforcement and litigation updates, which is always my favorite, starting with our DOL enforcement actions. So first we have an action where the DOL has found $61,000 in back wages needed to be paid to an employee, where that employee notified their supervisor that they needed FMLA protected leave. And a mere 3 hours after providing the certification on that leave, the employer notified the employee that they weren't going to be renewing their contract. This really speaks to the fact that timing is important. Secondly, a $39,000 in back wages where the DOL was investigating a roofing and asphalt manufacturing company that alleged that there was a wrongful violation of the FMLA when they terminated an employee immediately after providing the medical certification, and the employer asked for that recertification earlier than what they were required to. So again, the DOL provides very strict guidelines on when recertification can be asked for, and employers should really stick to those guidelines. Moving on now to our EEO settlements. First, with an extremely large settlement, in this case, kind of amazes me, was a settlement for nearly $7 million, where a hospital had a mandatory retirement age for physicians, regardless of their ability to do the job. That clearly would seem to be a violation of the Age Discrimination Act, which the EEOC had agreed with, which is why they brought this action, and it resulted in this very large settlement. Moving on to another large settlement, although not quite as large, $1 million and a 27-month consent decree. Here, the employer required applicants, these are people who have not yet been hired, to pass pre-employment medical exams, and they asked for medical conditions of family members like cancer and diabetes, and then also used what they learned from these pre-employment tests to deny individuals who had disability. So this clearly speaks to the fact that pre-employment medical exams are okay as long as they are job directed, but there's really no need to be asking about whether or not someone's grandfather had cancer. There's really no need to be looking at historical family things like that to weed people out based on their disability. Next, we have a $750,000 settlement with a 2-year consent decree, where an employee returned from medical leave and was not released to full duty, was kept on unpaid leave, and was refused a vacant position. And this speaks to the fact that when employees come back from FMLA leave and they're able to return, employers need to give them the same or an identical position. And then finally, there was a settlement here of a policy change where the employer was unable to do what they were supposed to do. Just move on to the next. Here we have a $100,000 consent decree, or $100,000 payment with a consent decree, where General manager of a hotel chain was terminated 2 days after telling the employer that he was seeking treatment for depression because the employer worried that he would hurt people. Two things of note here is the fact that timing again is important. This was only 2 days after the individual disclosed their disability. And secondly, you just, I mean, it really goes without saying, you can't make employment decisions based upon unfounded prejudices that you think someone might do something because they have a particular medical condition, in this case, a mental illness. Our next case is a $110,000 payment with a 3-year consent decree where the employer denied someone a religious accommodation to an employee who they said they had a Christian belief that required them to have a beard. The employer really wanted additional information to substantiate the employee's belief, and the EEOC disagreed. And really, this speaks to the fact that if an employee says they have a particular religious belief, don't test them on it. Don't ask them to show their bona fides that they're actually a part of this religion, particularly if it's for an accommodation as small as wearing a beard. Just trust them that they have those beliefs. And then finally on this slide, a $45,000 payment with a consent decree where, again, an employee requested religious accommodation to be exempt from the flu vaccine. And then the employer fired the employee, even though the employee worked outside and had limited interaction with the public. Again, after the Supreme Court's rulings on religious exemptions and religious accommodation, employers really need to take those things seriously and be able to show a true undue hardship if they're going to deny those accommodation requests. Next, we have a $150,000 settlement with a 3-year consent decree where the employer just refused to accommodate. This was a candidate, again, someone who was not yet an employee, who had a hearing impairment and used sign language, and they just terminated the candidacy because they said that verbal communication was an essential function of the job. The EEOC disagreed. Again, it's important to note that here, even candidates are entitled to accommodations if they are reasonable. And for individuals that have hearing or visual impairments, employers should make every effort they possibly can to accommodate those individuals, because it's going to be exceedingly difficult to show that those accommodations are not necessary. Next, we have a $100,000 settlement where the employer refused to accommodate a call center employee with an anxiety disorder. That individual asked to be reassigned to a position that didn't require them to field calls, and the employer refused, even though they had hundreds of jobs open, and didn't even discuss that potential. And I think the important point here is to note that employers really need to go through the process. You need to engage in that interactive dialogue to find out if there's another way that you could possibly accommodate an employee, and if there are open positions to provide them to that, to not just flatly deny accommodations. And then finally here, we have an employee who was legally blind and relied on a service dog and applied at a pizza restaurant, and the employer hired the person, but then refused to allow them to bring in their service dog. And again, it speaks to those with those visual or hearing impairments. And the one last thing I want to mention about EEOC settlements is, although we look at the top line number, another thing to note, and I'm sure I've mentioned this before, is the fact that these consent decrees can be extremely onerous on employers. And even though they're not directly money out of your pocket, it is time and effort that employees have to spend complying with these consent decrees instead of doing their job. So those are significantly important. Moving on to our actual litigation with the FMLA cases starting first. Here we have a case out of the 11th Circuit, Chandler versus Walton County. Here the employer terminated the employee, and the employee claimed it was retaliation for them requesting FMLA leave. The court disagreed and dismissed the case, essentially finding that the reassignment that the employer provided to the employee after taking FMLA was something that had been planned prior to the request for leave. So it couldn't be retaliation in that instance. And then in Lapham versus Walgreen, which is another 11th Circuit case, 11th Circuit seems to be popular these days. Here an employee was terminated for conduct and performance, and the court held that the employee failed to show that the reasons for termination were a pretext for FMLA retaliation. So here, to those that are familiar with the McDonnell-Douglas standard, when an employee claims retaliation, there's that burden shifting, right? The employee first claims that they were retaliated against, and then the employer has the right to show that, no, I didn't make this business decision. I didn't make this decision to terminate someone because of their disability. It was a business reason. And here, that business reason was that the employee had poor conduct, poor performance, and they could back that up with prior performance evaluations showing that the employee was not the best employee there was. Moving on to large case involving USERRA, which is the Uniform Service Employment and Reemployment Rights Act, essentially the ADA for those in military service. The jury found a $2.49 million verdict. And the interesting note about this case, before it got to a jury verdict, this case actually went to the Supreme Court with the state of Texas claiming they had sovereign immunity, that USERRA didn't apply to them because they are a state and they can't be sued. Supreme Court disagreed, allowed the case to go to a jury, and the jury did not find kindly to the state of Texas. Essentially, this was a state trooper who returned from Iraq to his position and had sustained a number of respiratory injuries as a result of being in front of burn pits. And this individual requested to move to a different position that would allow them to perform a job. Texas did not allow that, and they terminated this employee, and a jury found in favor of the employee. And the important thing to note is that USERRA really goes above and beyond the ADA. So for one, the term being disabled is different under USERRA. It's much easier to be disabled under USERRA than it is under the ADA. And furthermore, employers have to go above and beyond what they do under the ADA to accommodate employees. And it makes sense for individuals that are coming back from military service. Employers really should do all that they possibly can to allow those people to come back to work in some respect. Now moving on to some disability accommodation cases. We have Hampton versus the Utah Department of Corrections. Here, basically, the individual had a disability, had difficulty in grasping and pulling, and asked for a different kind of firearm other than what Utah regularly issued to their corrections department employees. Utah disagreed. They said that using a standard issued firearm was a requirement of the job, and the court found no, that being able to utilize a firearm, yes, is an essential function of the job, but precisely which firearm it is doesn't really matter. So that was a required accommodation, or at least it could be a potential accommodation. Moving on to Saluga versus Sinclair Insurance Group. Here we have an employee who developed early onset Alzheimer's disease, and that resulted in some performance problems, and then sued when they were terminated. The court dismissed the case for a couple of reasons. One, they found that there was really no request for an accommodation, and that the employee could not perform the essential functions of the job, and the employee didn't participate in the interactive process. So this really speaks to the fact that employees have responsibilities too. Even though they've asked for accommodations, they need to participate in the process. They can't just say, I have a disability, I need an accommodation, and that's the end of it. They need to participate as well. Moving on, we have Cerulean versus the Texas Department of Criminal Justice. Here was an administrative assistant who did not return to work and claimed that she could have been offered a desk job. The court found that the employee never made an accommodation request, and there was no evidence that any desk job existed. I think this case fairly speaks for itself. In Bennett versus Hurley Medical Center out of the Sixth Circuit, a nursing student wanted a service dog due to anxiety. However, after the service dog was allowed, an employee and a patient reported an allergic reaction, and then the employer offered an alternative accommodation, but the employee declined. And the court in this case found for the employer. And I just want to point out here that sometimes it's important to grant accommodations, even though you're not sure you can, for a limited period of time, so that you can show that that accommodation is not really effective or does not work in some way. You can say, we tried it and it didn't work. Additionally, employees are not entitled to the accommodation of their choice. They're entitled to an accommodation that will allow them to perform the essential functions of the job. And if that's something different than what they originally asked for, then that is sufficient. Moving on to, which I'm sure I'm going to not pronounce this name correctly, to Sarkistan versus Austin Preparatory School. Here was a teacher who asked for numerous accommodation requests of continuous leave. Finally, there was an additional request of 3 to 6 months leave, which the school denied, and the court upheld that denial, essentially finding that being in person to teach kids is an essential function of the job. And if you can't be there in person, you can't perform the job. So there's no need to accommodate that further. Our final two disability accommodation cases is Getter versus Schneider National Carriers out of the 11th Circuit again. Here, the employee was given part-time work and the ability to work from home as a temporary accommodation after their FMLA expired. But then after a number of months, the employer denied to continue that accommodation. And the court found for the employer, really ruling that full-time in-person work is an essential function of the job. But what's important here is it really depends on what the job is. If the job can be performed at home, and if other individuals in that position are performing their job from home in a remote position, then employers really need to consider those accommodations more seriously. So nowadays in our post-COVID world, if we're denying work from home accommodations, you really need to think about whether or not those essential functions can be performed at home or need to be required in the office. And then finally, we have Stanley versus the city of Sanford in Florida. Here, a former employee wanted to continue their benefits for a longer period of time after they were no longer employed. And simply the court ruled that the ADA only applies to those that are currently employed. Post-employment accommodations are not a thing. Now moving on to our religious accommodation case in Gage versus Mayo Clinic. Here, the employee refused to complete a religious exemption request from a vaccination requirement. And, the court found for the employer because the employee, again, they have responsibilities too. Even though there are heightened requirements now for religious accommodations, employees still need to engage in that process and provide information to employers so that they can make a reasoned decision as to whether or not to grant those accommodations. And our final case to go over, a case with facts that are not great for the North Carolina Department of Transportation. This involves an employee who requested a safe and quiet room to express breast milk for a lactation accommodation, and initially was outright denied, but then eventually the job offered her a records room to be designated as a lactation room, but apparently did not inform any of the other employees that this was a designated lactation room because people kept walking in on this woman as she was trying to express her breast milk. Sometimes they wouldn't leave, other times they would make fun of her. So naturally, the court denied the employer's request to dismiss this case, and it moved on to a jury. And again, this speaks to the fact that the EEOC, the DOL, and the courts take seriously the fact that if pregnant or post-pregnant employees require a safe and quiet area to express breast milk, employers need to grant that. Now, I'm going to move things on to Marty, and she can give us her quarterly compliance lesson.
Thanks, Eric. Wow, lots going on. Before I dive into our compliance lesson, I want to revisit Shelby's amazing presentation. And if your heads aren't spinning with all of the changes and developments going on in the paid family and medical leave world, kudos to you. What I want to mention is that Shelby blogs regularly on any concrete developments. She tracks all those proposed changes, but we don't typically blog about those until such time as they are enacted. And if they're significant, she'll keep you posted. And our best resource for you on everything that has been enacted is our resource that summarizes in fair amount of detail each state's paid family and medical leave law, disability law, whatever the state may have. And there was a link to that resource for you on the slide in Shelby's presentation that contained the map towards the end of her presentation. So I just wanted to remind everyone that there's help out there, that we stay on top of this stuff and offer you what we can as it becomes pertinent. So now let's turn to our compliance lesson of the quarter. Today, we're going to look at ADA association discrimination. And I would guess that many of you have never heard of this, and those of you who have may not fully understand the breadth and scope of this association provision of the ADA. And what brought this to our attention and made us consider this for our compliance lesson was a recent headline from the EEOC announcing one of those consent decrees Eric was talking about. Chesapeake Montessori School agreed to pay $85,000 to settle an EEOC discrimination lawsuit. The EEOC alleged in a nutshell that the school did not renew a longtime teacher's contract because excuse me, because it assumed that her daughter's disability coupled with the COVID pandemic would undermine the teacher's focus, her ability to give her all to her job that is required. And instead they fired her or failed to renew her contract, and instead renewed the contract of other teachers with less experience and tenure. So the question is, how is this an ADA violation when the employee is not disabled? Well, here's a quick summary of the association provision. It protects applicants and employees from discrimination based on the relationship or association with an individual with a known disability. Now, known disability means known to the employer because they can't discriminate on the basis of a disability they don't know about. The phrase relationship or association, that's all the statute gives us. Very bare bones in that regard. We'll look at that in just a moment to put some more detail on that. According to the EEOC, the purpose of this provision is to prevent employers from taking adverse actions based on stereotypes and assumptions about people who have some sort of relationship with someone with a disability. That is in these regulations appendix, but also in this link here. This is a sort of dated EEOC question and answer about the association provision, but nothing has changed. So it is still a very good resource for you to look at. And there are several things that we refer to in here. So what does that relationship or association mean? The regulations expand a little bit by saying it is a family, business, social, or other relationship or association. So that helps a little bit. It broadens and puts a little bit of explanation on relationship and association. The EEOC document that I referred to on the last slide gives us some examples of the types of associations that are protected. And it's really broad. The most common is going to be family members, but it also covers relationships with roommates, significant others or partners, non-spouse partners, friends, participants in an employee's off-duty activities, people associated with an employee's volunteer work, or coworkers at an employee's second job. So these are just examples. You have to think very broadly on this. So going on to the next slide. Here's some examples of the types of employee rights that are protected. And it's the same as other types of discrimination. You can't discriminate based on an association with a disabled person in hiring, promotions, et cetera. Other terms and conditions of employment. The last one on the list there, work-related social activities, is a real curiosity to me. And we're going to, in a little bit, take a look at an example of what that means. There are various kinds of factors that an employer might take into account that would constitute association discrimination if they take these factors into account in making an adverse employment decision about someone associated with an individual with a disability. One is expense, that you can't refuse to hire or retain an employee because of a concern about higher insurance expenses, for example. Another category is disability by association, basically concerned that the employee will contract the same type of illness that one of their associates has. AIDS is a common example there, or will suffer from the same health problems as family members, such as cancer. Your sister had cancer, so I'm afraid you're going to get cancer, so I don't want to hire you. Distraction is another category. This is very common also, concern that the extra demands of caring for a disabled associate will cause the employee to be distracted or inattentive or to miss work. That was what the Montessori case was about. And then otherwise, just basically treating employees differently because of their association with a disabled person in a negative way with respect to those terms and conditions of employment. The next couple of slides have some examples, and I'm not going to go through each of those. I just want to point out a 2 or 3 key ones. And I've labeled each of them as to the nature of that discrimination that's going on here, that motivation. Number one is that expense thing. An employer refuses to hire the applicant because her spouse's disability is going to increase their health insurance costs. Number two is that when I was talking about work-related social activities, and this is as an example provided by the EEOC in the document, the questions and answers document that we linked to. Their example is an employer tells a new employee not to bring her disabled child to a holiday party because of concern that the child will frighten or make other children uncomfortable at the party. That's an example of different treatment. I'm not sure most of us would have thought of that as discrimination, actionable discrimination, but according to the EEOC, it is. So they, as you see, they're interpreting it very broadly. On the next slide, one other example I want to point out is number 5, where this is that distraction argument, and this is a very, very common one that we see where the employer is afraid that the applicant's need to care for a disabled associate relationship is going to cause excessive absences or inattention at work. So lots of examples there to help understand what this provision is all about. A little bit of good news here, which is that there is under the ADA no duty to accommodate an employee based on association with a disabled person. And here is an example. You don't have to give an employee a modified work schedule as an accommodation to enable the employee to care for a spouse with a disability. Now, there might be some FMLA rights going on there, but under the ADA association provision, no duty to accommodate through a different schedule and so forth. This case, this principle was first established. It's not spelled out in the statute. It was first established in the Den Hartog versus Wasatch Academy case in 1997. But it has been reiterated and reaffirmed many times since. I gave you here an example of a 2023 case citing to Den Hartog and holding the same to the same principle. Let's see, if we go right on, another point to make is that in California, things might be different. We love California, don't we? And California has a statute called the Fair Employment and Housing Act that contains within it California's a similar statute similar to the ADA at the state level. Here's a big difference, though. The FEHA definition of disability actually includes someone who is associated with a person who has a physical or mental disability, which means that because that's a disability, the accommodation provision might apply. This was first brought up in this Castro Ramirez case, and the procedural history of that case is very complicated. We don't need to worry about it. Bottom line is that although the courts recognized that it was not key to a holding, so it's not a binding ruling. However, one federal court did follow the Castro Ramirez ruling in another case, also named Castro, no relation, that did apply the duty to accommodate, or at least recognized it within the context of the case because of the California language in the Castro Ramirez case. So watch out for California. There are no further California cases on this. The California Civil Rights Council, which promulgates regulations, has tried to has had this issue on its agenda for consideration for regulations for years and is doing nothing. So last important point that I want to make is that the direct threat defense under the ADA does apply if an employee's a disabled person the employee is associated with or has a relationship with is posing a direct threat to the harm and safety of the individual or others at the workplace. And so the ADA does permit an employer to discipline or discharge a non-disabled employee. Well, let me correct that. that phrase non-disabled employee should be taken out. Does permit the employer to discipline or discharge an employee, regardless of whether they are disabled or not, whose disabled relative or associate poses a direct threat to the employer's workplace. And again, this was established in the Den Hartog case. So you can apply that direct threat. And because there's no duty to accommodate the associate, the employee because of the associate, there you can establish a direct threat without having to go through the accommodation provision process. Our last slide here is some pointers on how employers can make sure that their company is recognizing and honoring this association provision. And the main key here is training supervisors to be aware of the prohibition, how broad the definition of association is, and how it applies in all aspects. The last point I want to make is that if an employee's association with a disabled person in fact causes performance problems, you can apply the usual discipline procedures. I would recommend getting HR help on it. An example of this would be you can't refuse to hire someone out of concern that caring for a disabled associate will cause attendance problems, but you can apply the usual discipline or performance counseling rules if in fact the employee does have attendance issues, even if they are caused by their association with a disabled person. So don't use it as a decision point, but you can use it as, you can address the performance issues as always. And here are our resources for you on this. And that is our compliance lesson of the quarter. Thank you.
All right, doesn't look like we had any questions up until this point. I do want to remind everybody that all registrants will be receiving a copy of the deck as well as a copy of the recording of the presentation. With that being said, I believe we're at a time where we can close. Thank you, everybody.